For those of you who I have not yet met, my name is Professor Allie Orr Larson. I'm happy to be a professor here at William & Mary, and it is my privilege to moderate the first panel today, which is on the civil jury's role in the structure of our government. So we have two distinguished guests. To my right is Professor Suja Thomas, who is from the University of Illinois and an expert on the Seventh Amendment, among other jury-related things and other things. And to my left is Professor Stephen Landsman, who is the Professor of Law and Robert A. Clifford Chair in Tort Law and Social Policy at DePaul University, who is a leader particularly on empirical and historical aspects of the jury. So with that being said, Professor Thomas.
Thanks for having me. The civil jury has been in decline. Many fewer juries are convened than in the past, and there's no promise for any change. The decline of the civil jury is often attributed to the incompetence of the jury, the inefficiency of the jury, and that settlement and arbitration are better ways to resolve cases. I want to offer a different story, one which shows that the executive, the legislature, the judiciary, and the states have caused the decline of the jury by placing the jury in subservient roles to themselves, and in turn those actors have given themselves more power. I will make three arguments in this presentation. First, courts and the other branches have treated the civil jury as inferior to themselves, taking power from the jury and in turn increasing their power. Second, the civil jury should be viewed as a co-equal of the branches, as effectively a branch, a separate constitutional actor with independent power. And third, to treat the civil jury as a co-equal, when interpreting the jury provisions in the Constitution, courts should use originalism to determine what power the jury holds. While the focus of the symposium is on the civil jury, I will make these points more generally for the civil, criminal, and grand juries in a book that I'm writing, which basically is saying that the jury is the other branch. But now, focusing on the civil jury, on the first point, courts and the other branches have treated the civil jury as inferior to themselves. The institution holds just a fraction of the power that it held in the past. Let me illustrate this point by discussing some of the procedures that courts and the other branches have adopted that have curtailed the civil jury trial right. First, courts have taken power from civil juries through judgment as a matter of law, summary judgment, the motion to dismiss, and remittitor. Under judgment as a matter of law, a judge takes a case from a jury after a jury has rendered a verdict for the plaintiff because the judge thinks a reasonable jury should not have found that way. Remittitor also second-guesses a jury. It permits a judge to reduce a jury's verdict to what he thinks a reasonable jury should have found. Under summary judgment, a judge takes a case away from a jury before a jury has had the opportunity to hear a case. The judge orders summary judgment if he thinks a reasonable jury could find it only one way. Another method whereby a judge can take a case from a jury before a jury has had an opportunity to hear a case is the motion to dismiss. Here, a judge can dismiss a case before any discovery is conducted if, using his judicial experience and common sense, he believes that the claims are implausible. The problem with all these modern procedures is that they impermissibly take power from the civil jury. The Seventh Amendment governs the civil jury trial right. It's the only place in the Constitution to refer to the common law explicitly, and the Supreme Court has said that common law in the Seventh Amendment means the English common law in 1791, the date when the Seventh Amendment was adopted. And the court has said that in deciding whether a procedure satisfies the Seventh Amendment, the procedure must satisfy the substance and not the form of the English common law. So, to decide if the judiciary has taken power from the jury, we need to examine the English common law. In the late 18th century, when the Seventh Amendment was adopted, no procedures similar to any of these modern procedures existed under the English common law. In fact, the procedures are contrary to the English common law. Under this law, one party could admit the allegations or the conclusions of the evidence of the other party, or the parties could leave the determination of the facts to the jury. The court itself never decided a case without a determination of the facts by the jury or the parties, however improbable the evidence might be. Only after the parties presented evidence at trial, and only after a jury rendered a verdict, could a court ever determine whether the evidence was sufficient to support a jury verdict. Even then, if a court decided that the evidence was insufficient to support the verdict, it would order a new trial. Judges then, through several procedures, have increased their own power and decreased the power of the jury. Moving from the courts to the legislature, the only branch that was to have any check on the jury was the judiciary. And you can see this, I think, in the text of the Seventh Amendment. With that said, Congress has taken power from civil juries, delegating certain damages decisions to bankruptcy courts. Again, questions that were within the power of the jury. Under the Seventh Amendment, a jury decides suits of common law that are above $20 in value. I have shown in other work that under the English common law, almost invariably, damages were decided by juries. It follows that under the Constitution, juries were to decide the damages to be awarded to a plaintiff. So like the judiciary, the legislature has taken power from the civil jury and in turn given itself more power. Now the executive. The executive has auspices over agencies like the National Labor Relations Board, and courts have decided that juries are incompatible with the administrative scheme, even though these agencies can determine damages, a question within the power of juries to decide. So the executive also has taken power from juries and in turn increased its own power. And finally, the states. While the court initially decided that many rights in the Bill of Rights were not incorporated, it changed its decisions over time with respect to each of those rights, except the incorporation of the civil jury right, the grand jury right, and the criminal jury unanimity requirement. Those rights, including the civil jury right, oddly remain non-incorporated. The states, in turn, do not require civil juries, including in many cases with significant damages. I've studied these non-incorporated rights, and these rights, including the Seventh Amendment, are no different than the other rights that have been incorporated. They should be incorporated. So my first point has been that the courts and other constitutional actors have treated the civil jury as inferior to themselves, taking power from the jury and in turn increasing their own power. The second argument that I want to make is the civil jury should be viewed as a co-equal of the branches and the other constitutional actors, as effectively a branch, a separate constitutional actor with independent power. In some ways, this seems like an odd proposition. When we think of the Constitution, we think of the constitutional structure as composed of the separation of powers between the executive, the legislature, and the judiciary, and federalism as the separation of power between the federal government and the states. The jury isn't mentioned when these structures are discussed. At most, the jury is mentioned as a part of the judicial branch. The structures of the separation of powers and federalism give value to the powers, respectively, of the executive, the legislature, and the judiciary, and the states and the federal government, specifically the importance that each does not impinge upon the power of the others and that the powers of each be maintained. The importance of each of these powers is exhibited by the fact that none of these entities is viewed as dispensable, and it's not viewed as acceptable to decrease the power of any of these entities. But I think we can contrast this treatment of these traditional branches and other constitutional actors with the treatment of the civil jury. As I described, there's been an accepted decrease in the power of the civil jury. Moreover, academics regularly discuss that the jury is not as important as it used to be. If I may, I don't know where Bill is, but I'm going to invoke Bill. Bill Nelson has stated, Professor Nelson has stated that the civil jury is essentially unimportant, comparing it to the Contracts Clause, both of which he calls legal citing as compared to the important Equal Protection Clause. John Langbine has stated that the procedure I've mentioned as problematic is good in that it gets rid of meritless cases, and in other cases there's no civil jury trial because people settle because they don't need a trial or they can't afford one. Despite these arguments, the text of the Seventh Amendment and the historical reason for the Seventh Amendment support that the civil jury is a separate, important, independent constitutional actor like the executive, the legislature, the judiciary, and the states. The text of the Seventh Amendment gives the judiciary only one way to check the power of the jury, and that is according to the rules of the common law. Moreover, no other branch or constitutional authority is given authority over the jury. What's stated about the role of the jury is consistent with the text, that juries were checks on judges. For example, John Adams stated, as the Constitution requires that the popular branch of the legislature should have an absolute check so as to put a peremptory negative upon every act of the government, It requires that the common people should have as complete of control as decisive and negative in every judgment of a court of judicature. Speaking of the relationship between the judiciary and the jury, Hamilton stated, "It will readily be perceived that this complicated agency tends to preserve the purity of both institutions. By increasing the obstacles to success, it discourages attempts to seduce the integrity of either. The temptations to prostitution which the judges might have to surmount must certainly be much fewer while the cooperation of a jury is necessary than they might be if they themselves had the exclusive determination." So by permitting judges to take cases away from juries under a flexible standard like plausibility under the motion to dismiss, or deciding what a reasonable jury would find under summary judgment, takes away the check that the jury was to perform on judges and leaves judges as the only people who are running things. With the jury treated effectively as a branch, the respect that's given the executive, the legislature, the judiciary, and the states is also duly given to the jury, giving it a fighting chance of survival. My final argument is in order to treat the civil jury as a co-equal, when interpreting this jury provision in the Constitution, the branches and the other constitutional actors should use originalism to determine what power the jury holds. Think about it this way. Anytime the judiciary, the executive, the legislature, or the states acts to limit the authority of the jury, it actually gives itself more power. Thus, when a judge decides a case on summary judgment, the jury has less power and the judge has more power, the judge being permitted to decide the result in the case. Whenever the judiciary takes power from the jury, then it simultaneously gives itself power. In other words, the jury and the judiciary compete for power. Similarly, the executive, the legislature, and the states compete with the jury for power. This competition for authority is different than other competition for authority, for example, between the states and the federal government. If the Supreme Court decides that states can't legislate in a certain way regarding abortion, states can continue to push legislating to further their policy objectives. The jury is in a very different position, a particularly perilous position with no ability to protect its authority. If authority is taken from the jury can't even attempt to recover any of this authority. With this type of imbalance, the question is how the jury right can be maintained. We can look at the intention of the founders. The founders could have intended the difference such that the jury would have less authority, and authority depended upon the discretion of the traditional actors. On the other hand, the difference in the jury's ability to act in conjunction with the constitutional text could show that the founders took the difference into account by tying the civil jury to an established framework of power. In other words, it makes sense for the framers to have crafted the civil jury provision in the manner in which it's written. And I think this latter argument appears more persuasive given the text of the Seventh Amendment. So I argue then that to preserve the authority of the jury, because of the position of the jury as unable to protect its own authority, the other actors have to act with what I term structural modesty. Using the judiciary as an example, what this means is the judiciary must narrowly interpret its own power in relationship to the jury's competing power using the text of the Constitution. More generally, what I suggest is that this narrow interpretation must be according to the rules of the common law, and that being the English common law. So you might ask, why the English common law and not an evolving common law, as non-originalists would encourage? I think this is a place where the founders believed originalism was necessary. If the other constitutional actors, including judges, could decide to dismiss cases whenever they wanted under an evolving common law, the jury authority would be meaningless. The English common law gives a set point in time at which to evaluate the propriety of the procedures. The English common law was developed and consistent, and Justice Story recognized that the founders intended common law in the Seventh Amendment to be the English common law in 1791. I argue that the judiciary and the other constitutional actors should act with modesty using the English common law when they interpret their own power in relationship to the authority of the jury. What this means, as an example, is that the judiciary would act with judicial modesty when it looks at summary judgment and see that nothing like summary judgment existed under the common law, and thus that the judiciary should not use this procedure to take a case from a jury. If the other constitutional actors can recognize the jury in this role as effectively the other branch, the jury right with juries in only approximately 1% of civil cases, I think, can change and will be closer to what the founders envisioned, and members of our society can actually participate in deciding how our society is to function on a day-to-day basis. Thank you.
Thank you so much, Professor Thomas. And now Professor Stephen Landsman will talk to us about juries as regulators of last resort.
If you want to know when the dean of the law school does the argument, it's when he puts you in the slot that you read the Because it's at that moment that all those carbs from lunch hit you, and everybody's like, oh my God, I stay awake from this. Well, we'll try to keep you awake. I guess I'll start by thanking the people who put this symposium together. You may not, some of the students in the room may not know, but you've really got in the room some of the very best people in the country on these matters of jury trial. And to have Senator Whitehouse too was really quite a treat, because he said at least some people in the government are thinking about these matters, and that's very encouraging. For me, the honor is really double to be here. One is just to be amongst this distinguished crowd, but the other piece is that my son Peter is a 1L here. And what a treat it is for me to be able to come to talk. So thank you and thank you. If you were asked to select one word to describe national politics today, I'm guessing that many of you would come up with the word gridlock. Well, it's part of the thrust of my remarks today that I think of juries as gridlock busters. You might be too, I suppose, if you were locked in a room with a bunch of strangers and required to sit there until you came up with a solution to a problem that might have serious implication for someone else's life. My paper in this symposium focuses on one of the places where juries have been imported as gridlock busters to fix and enforce regulations that are essential to the well-being of people in our community, and no other entity in the community will reach out and help them. In my paper, I describe this situation as jurors fulfilling the political role of regulators of last resort. And it's being triggered when truly awful things are happening to some members of the community, and the executive and the legislature won't do a thing about it. It's a commonplace observation in today's America that government often doesn't do its job, doesn't work, doesn't regulate effectively. The reasons are many, and we can probably all tick them off, right? A lack of resources, a fear of backlash or political repercussions, the adoption of a sort of laissez-faire philosophy, the capture of the regulators by the regulated, and the flooding of the public discourse with a single point of view. The claim that the jury can be a regulator of last resort, I think, needs some defending in this context. After all, regulation is usually not a one-shot deal, but an ongoing guide to conduct within the society. It would certainly be easier to claim that it's the judiciary that is the regulator of last resort, and that the jury is simply its cat's paw. If you know anything about cats, though, you know that as a group, they're very hard to herd. They have their own particular opinions about mice, about birds, and also about closed doors. They always want to know what's behind there. Juries have been the same. When courts did not want them to poke into questions of negligence related to railroad crossings and workplaces, the judges ratcheted up the doctrine of contributory negligence. And they said it would be up to the judges to take cases away from the juries whenever the judges thought that the juries had missed questions of contributory negligence. Well, contributory negligence is a stupid and a cruel doctrine. It ignores the reality that accidents are seldom purely one person's doing. It also leaves a lot of injured people out in the cold. The judges somehow didn't get that, but the juries continued to understand those fundamental insights. On contributory negligence, juries like cats resisted being herded. They kept ignoring evidence of contributory negligence. They kept shaving dollars off of judgments to reflect comparative fault. The judges eventually recognized that their wrong-headed rigidity was an embarrassment to the system of tort law, and they came around to the notion that the jury had been pursuing all along comparative fault. In their contributory fault verdicts, jurors created a new legal norm. I think they did so in a number of other contexts as well. How do we send our most significant signals in American society? Well, I think we do it with money. We all recognize the refrain, money talks. Those punitive awards, even having been curved after Campbell versus State Farm, send unmistakable messages. As the messages pile up, they get harder and harder to ignore. If you have any doubt about that, just ask some of the asbestos companies that are no longer in business. Of course, judges play a very large part in this process, but jurors do as well. It's the jurors who fix benchmarks. It's the jurors who make headlines. It's the jurors and their awards that motivate lawyers. The jury process is set up to send bold monetary signals. It does so when it allows for the delivery of general verdicts, verdicts that are hard to break down and hard to curb. It also does so when it puts the punitive damages power in the hands of jurors. What have jurors been signaling about in American law in the last 20 or 30 years? Well, certainly about what the right price for injury is. And their price is usually a good bit above what the judges would otherwise award. Similarly, jurors are the ones who are talking about pain and suffering, underscoring its importance in a society that's been more and more tempted to ignore that part of the hurt that some do to others. Juries have also been consistent signalers in the so-called bad baby cases, where our administrators and our legislators have failed to cure the untenable situation, which often leaves badly injured infants in a situation where there's absolutely no safety net. It's been suggested that monetary signaling may also be at work in medical malpractice awards and in products liability cases, where the awards are larger, although the damages or injury may be the same when compared with injuries in auto cases and injuries in premises cases. These signals have been heard. They clearly have been heard by those plaintiffs' lawyers who have filed a lawsuit. They've also been heard by the defendants' lawyers who are recalibrating benchmarks and settling cases. I think the signals have also been heard in corporate boardrooms, and there hasn't been a great deal of joy and happiness about the signals that have been sent. Finally, I think that the public hears about these sorts of signals through media reports, although some of them are grossly distorted. This communication is by every measure imperfect, but it is nonetheless an important signal from the jury about the way our society ought to work. In my piece for the symposium, I explore a particular place where jurors have been called in to be regulators of last resort. The place that I focus on is insurance company mistreatment of those seeking compensation for loss. How do juries come to regulate insurance company treatment of their customers? First, it was an area where no one else was regulated. The Congress in the 1940s prohibited the United States government from regulating the practice of insurance. It did so in the McCarran-Ferguson Act. The states do regulate in the insurance area, but they do a lousy job of protecting consumers. Mostly that can be explained by the usual set of reasons: capture of the regulators, lack of resources, different priorities. Into this unregulated or badly regulated area as far as consumers are concerned came a group of people who were left absolutely unprotected. They weren't, almost by definition, weren't able to defend themselves. They were the victims of a variety of injuries. They were mostly people who now were economically near zero, who were hurting and were homeless, who could not on their own afford lawyers, and that was their situation when they came to ask for appropriate relief from the insurance companies. The third piece of this equation is the insurance companies, who abused their market power, exploited those who relied upon them, and greedily sought to cheat and dissemble their way to larger profits. Into this perfect setting for abuse stepped the California courts. Gingerly at first in the late 1950s, they asked juries to assess whether insurers had displayed good faith and fair dealing with their customers. The juries, in ever louder tones, said that no, in the cases that were decided, the insurers had not been fair. The jurors said that in cases like Kriski, where an insurer gambled a widow's life savings and lost everything for her. They said it in the Fletcher case, where another insurance company tried to cheat a father of 8 out of $150 a month because they didn't want to continue to pay him after he was disabled on the job. And the jurors said the same thing in the Silberg case, where for more than 2 years an insurance company refused to pay what was owed while watching its own client suffer a series of nervous breakdowns and eventually the repossession of his wheelchair. As the stories got worse, and obviously I picked out ones that make that point, and company behavior more despicable, the monetary judgments grew. The basis for liability was expanded. The jury spoke, and the money it awarded grew larger and louder. The jury began to curb the insurance industry through fear, which legal economists usually refer to as deterrence. The deterrence wasn't perfect. Bigger cheating schemes continued to be uncovered, and all of them related to insurers' efforts to overreach. Eventually, that good neighbor, State Farm, was hit with a $145 million punitive damages judgment for a grossly manipulative and greedy scheme in Utah. That signal was so loud that the Supreme Court of the United States decided it was time to turn down the volume, though one can doubt the wisdom of the court's intrusion in that particular case. The story in the bad faith insurance context is clear. When there is inadequate regulation, when the weak are victimized, when the strong run amok, there the jury may be called in as a regulator of last resort. The lesson is one to be noted. The approach employed in the insurance context deserves to be considered in other similar settings, most particularly where the strong impose grossly unfair requirements on those they deal with, as in binding arbitration. By acting in such contexts, the jury indeed can serve as a regulator of last resort, a political fail-safe for our society. Thank you.
Thank you. Thank you both so much. So we have about 15 minutes for questions, but I'm going to use the moderator prerogative and ask the first one, which for both of you, it's a question about juror apathy, right? So when you ask people on the street about jury duty, sometimes you get the kind of response. And I'm wondering if that response and perhaps the attitude that then is brought into the people that can't get out of jury duty, if that influences our thoughts on their structure, their role in our structure of government. Maybe it makes them less important, or maybe it makes them, we're less comfortable with them as the last resort, but I just would like to know your thoughts on that.
Yeah, I think you're totally right that that does in fact influence how we think of them. At the same time, I think that once people actually serve on a jury, they start thinking of the jury in a different way. I certainly have heard people talk about it that way, and so I think that's how we can get people more interested in the jury.
I think it was Albert the alligator who said, "We have met the enemy and they is us." We're all the jurors, and it's up to us not to share those attitudes. And as Suja just said, once the experience is had, the views of those who have been jurors are very different about the process. And part of the burden that we all share as lawyers is to communicate to the rest of the community about the mechanisms we use and the way to make them effective. So I think the challenge is for us.
Great. Okay, some questions? Is that a hand or almost a hand? Your hand is up. Go for it. Yeah.
I'm caught by my little hand gesture you made, perhaps like the apathetic juror. But I guess my question for Professor Landsman primarily, and that is, how do we really know that the regulatory system that the jurors create in these instances where they can see whether it's not regulated enough is actually superior to what would exist otherwise? Yes, it's easy to find horror stories by obviously you can find horror stories the other way as well, where juries awarded excessive judgments or badly reasoned judgments or failed to award a judgment they shouldn't have. Also, even in the horror stories you mentioned, I would wonder, what was actually in the insurance contract? Did the company actually contract to compensate people in this instance? If they didn't, then it creates a lot of perverse incentives to require compensation after the fact. It also raises insurance rates and the like, may make certain kinds of insurance less available to begin with. So I guess, what is the systematic reason to believe that juror decision-making in these kinds of areas will be better? Granted, the political system is imperfect, the executive is imperfect, and so forth, but there are also lots of flaws in jury decision-making, particularly in terms of consistency across cases and the like. So how do we know what are the criteria that you would use to judge that?
The question would be a harder one if it weren't for the fact that we had nothing before. I mean, my response starts with the observation that there was no regulation.
Sometimes that's the right way to go.
Well, you may believe that. And of course, the problem is that those who are successful and powerful and have all the resources at their disposal incline to that view. But when you're on the bottom of the heap and you have no leverage at all, that's a pretty difficult proposition to sell. Now, the cases that the California juries decided are pretty clear cases of gross overreaching. Or the Campbell case is a clear example of gross overreaching, a 20 to 25-year scheme to enhance the profits of an insurance company by denying legitimate claims and memos in the files saying to do it. Now, the Utah Supreme Court, no bastion of liberalism they, came up with a $145 million compensatory award. The trial judge had reduced it to about 20 or 25 million. The Utah Supreme Court came back and said, what these folks were doing, these powerful insurance folks were doing, was not in the interest of Utah, was not in the interest of the nation, and ought to be changed. Now, when there's nothing, and that's what's going on, I challenge you to think it's a better system.
As I said, it's easy to find horror stories on either side. The question is about a systematic reason why one approach is better than the other one.
Okay, yeah, next question.
I've heard I hail from Connecticut, the land of insurance. But I want to, I really like going to projects a lot and enjoy the content. I want to push Professor Thomas a little bit on a couple of historical things I've read. I think the focus is first. So, correct me if I'm misrepresenting this. I heard you both are in favor of incorporation of the Seventh Amendment into the state. As well as arguing in favor And then, and then the historical text is created by Justice Story, is sitting, better than me, sitting on the writing circuit and the first circuit in 1812, and before the war of 1812, and I read it as a national project. Senator mentioned commercial Justice Story about throwing on the side of having the application of law in favor of the commercial interest. And so I just wonder, is that the best test? Is English common law, even if it were uniform and even made sense to apply, is that really what, is it really an original effect that you want? One, two, if that's what you want, how do you effectuate it in a legal system that's now largely based on acquisitions and achievements or comparison in that regard? So I just wonder how you respond. I mean, sure we thought about those things. I wonder how you respond to those sort of counter arguments. And the same is true for the Seventh Amendment being incorporated against the state. It was supposed, I understood the Seventh Amendment as being a protection against the federal government. And there's a nice article I read called Economic History of the Seventh Amendment, or Economic Origins of the Seventh Amendment. I wonder what you think about that. And, maybe it is really, both of those are really the way we should go. But I just wonder about the reaction.
Sure, thank you, and thanks for reading my work. And I will send you my most recent piece, which is called Non-Incorporation, which is where I actually argue that the Seventh Amendment should be incorporated, the grand jury should be incorporated, and the unanimity requirement and the sixth should be incorporated. I guess I would say I think it's a great question to sort of say why it should be the English common law in 1791, and I would say that I think both the text and the history support the English common law in 1791. When we think about the Seventh Amendment and the language of the Seventh Amendment, in suits at common law, the right to a jury trial shall be preserved. And then the second part of it, where it only gives judges the opportunity to check the power of the jury according to the rules of the common law. To me, there are only a few different ways that could play out, that the common law, what it could be. Professor Amar has talked about the states being the sort of baseline, and that Congress can come in and can do more than what the states do. Others have argued that it sort of should just be some sort of other evolving common law. I think that the English common law is and was developed at that time. I think that if you talk about it being the states, one, there wasn't anything to preserve in the sense that other than the states that actually existed at the time of the Seventh Amendment. So in some ways that doesn't even make sense, I think, according to the text of the Seventh Amendment, which says that you're preserving the right to a jury trial. I also think that if you can talk about the states and what the states actually do, and it could actually change at any point in time, and that what Congress does on top of that could change at any point in time, that also doesn't give anything of value to the language preserved in the Seventh Amendment. And then the second part of the Seventh Amendment, that being the checking what the jury does and only according to the rules of the common law. Again, if that could change by what judges say or what by states do, to me, that doesn't give the jury really any significant power. And I think that if we did that, the jury right would be almost meaningless. So I think one, that the text, I think, definitely supports it. I also think the history supports it. I think that Wolfram writes a really nice article in the Minnesota Law Review and did this great study about the Seventh Amendment and looked at all these different sources. And in addition to the protection of self-rule, he definitely talks about protecting the litigants against oppressive judges and several other reasons why the Seventh Amendment was in existence. So those are some of the reasons that I would support that I think the best answer for us using the text and the history is to use the English common law. And then, I know this is a long answer, but let me just sort of, just briefly on the non-incorporation. I mean, I think, again, you know, I've written more about this, but, you know, in the states themselves at the time of the Bill of Rights being enacted, 11 of the 14 states actually had jury rights, and at the time of the 14th Amendment, 36 out of 37 states had jury rights, and that in the discussion of incorporation, that's two of the points that are often talked about as to whether or not a right should be incorporated as fundamental. And so that, along with a few other things, sort of, I think, support also incorporating the Seventh Amendment.
I'd just add a brief footnote, and that is that when the Seventh Amendment was drafted, the resistors said that, gee, we have so many different approaches in the states, what should we do? We can't really write a good amendment. And the answer, in part, was to say, we'll take the English common law, which we know and understand. And
Okay, you can't agree, let's put in the word common law, that's something, and we'll figure it out later.
but they had really said, you know, the argument originally was, we can't draft it. There are too many different strains of jury trial. We just can't make it work. Mm-hmm. And this was a lovely way to meet on common ground. And you can describe that as sort of quitting on the project or as being a sensible compromise, which is where I would gravitate, I think.
Okay, I think we have time for one more question. I'm torn because then Professor Solomon. He's the one who invited me, so I have to pick him.
Thank you, President. Two questions for Professor Thomas Lansman and also Senator Whitehouse and Professor Marr tying into the theme. So the theme I'm hearing from Professor Lansman and from Senator Whitehouse is essentially corporate power or commercial interests own basically all of government, all branches of government. And the only thing that people have left is the jury. And then what I hear from Professor Thomas and Professor Amar is what we have to do is we have to strengthen the civil jury. We have to elevate the jury to be essentially a co-equal branch and let them decide more issues in the kinds of cases they come to. We may have to have them be more like the grand jury, part of the family, and have them serve for a week or two in order to strengthen them. I guess what I'm wondering is why that's the best way to think about the role of lay people in strengthening the voice of the people in government. I mean, why not, for example, have the people be more involved in the functioning of administrative agencies, for example? Someone named Dick Arcusha gave a talk here a few months ago, and they gave another piece of it. So if we had juries that were in the Consumer Financial Protection Board or the EPA that couldn't be bought, then we wouldn't need regulators of last resort to hear employment discrimination cases or bad faith insurance court cases, or let's be honest about in the state courts what most of the cases are, auto accident cases. And so why shouldn't we take a step back and think about how we can use lay people in government to solve the actual problems that we're trying to solve?
I think that it's a wonderful set of ideas, provocative and interesting, and especially those which suggest using modern technologies to create pools of people to respond. Be that as it may, it's sort of like pie in the sky, and you usually don't get it until you die. The evidence has been that we've whittled away even at the jury we have. That instead of the 12-person jury, we have the 6 or 8-person jury. And instead of the jury at all, we have arbitration or we have all these other things. So to suggest a reversal of flow is a wonderful suggestion. But let me just say how skeptical I am that we're going to get there. And if we're not going to get there, let's ask what we can really do. And that I think is where I'm coming from.
Do you have?
I agree.
Okay. I agree. All right. I think we'll continue the discussion in the next panel. So thank you very much.
Well, thank you.